Usually, when we talk about a medical diagnosis, there's this really clear expectation of precision. It feels, I don't know, almost like engineering.
Right. It's very scientific.
Exactly. Like if someone breaks their arm, they go to the hospital, the doctor takes an x-ray, and there's this jagged white line right there on the film.
It's undeniable.
Yeah, the doctor literally points to it and says, there is the break. It's visible. It's this objective fact that anyone in the room can verify just by looking at it.
And the human mind really naturally prefers that kind of binary system. The bone is broken or it's not. The evidence is just sitting right there on the light board.
Right.
But criminal law rarely offers us an X-ray.
Which is, frankly, the terrifying reality for anyone trying to navigate the legal system. Or, in the case of our listener joining us today, trying to master it for the multi-state bar examination.
Oh, absolutely. The MBE is a beast.
It really is. Because when we step into criminal law, the physical evidence, the broken window, the stolen car, the injured victim, that's really only half the story.
At best, yeah.
Right. The rest of the puzzle requires proving what was happening inside someone's completely invisible mind at the exact fraction of a second their body committed the act.
And you just cannot put a human thought under a microscope. You can't draw a drop of blood to, test for guilt or malicious intent.
Yeah, that's impossible.
We are essentially forcing a judge and a jury to peer into a dark room and declare beyond a reasonable doubt exactly what a defendant was thinking. The entire weight of a person's freedom rests on defining the invisible.
Wow. Yeah, that's heavy. And we are focusing entirely on that dark room today. And we are tailoring this deep dive specifically for you, the listener, preparing for the MBE.
It's such a crucial topic.
It is. The bar exam is notorious for presenting these incredibly dense, archaic legal concepts. It's a grueling test of endurance. But we know you might be facing an additional hurdle here, which is mastering this massive body of law while English is your second language.
The barrier there is significant. I mean, legal textbooks rely heavily on Latin phrases passed down from centuries ago. Oh, the Latin is the worst.
It's everywhere. And the sentences are often structured to be, intentionally complex. The exam writers use vocabulary to almost hide the actual legal mechanisms being tested.
Right. It's like a trick. So our mission today is to strip all of that away. We are dropping the confusing legal jargon entirely. We're going to translate the heavy common law principles and the model penal code rules into simple, everyday English.
That's the best way to do it.
We want to break down the mechanics of the law, how it works, and more importantly, why it works that way.
And to do that effectively, we really should build a visual framework, something you can hold in your mind during the exam.
Okay, I love a good visual. What are we picturing?
Well, when you're staring at a convoluted fact pattern full of distractions, having a clear mental picture really helps organize the chaos. So I want you to picture a simple three-sided triangle.
Just a basic triangle.
Right. This triangle represents the foundation of every single criminal offense.
Okay, so a three-sided structure means we need three distinct points to connect. Let's label them. Point number 1 is the actus reus.
Which is the Latin.
Right. But translated into everyday English, that is simply the physical act, the bad action.
Got it. Point 1 is the physical act.
Point number 2 is the mens rea, which translates to the guilty mind.
The bad mind.
Exactly. And the final point number 3, is causation. That is the unbroken chain linking the physical act to the final bad result.
Act, mind, and the link between them. So if the prosecutor can connect all 3 points of that triangle with solid evidence, they've built a crime.
They have, but, and this is important to make this mental map complete for the exam, we need to add one more element.
Oh, I love the shape.
Yeah, picture a small bubble floating completely outside of that triangle, totally detached from the other points.
Okay, I see it. A floating bubble.
We are going to label that floating bubble strict liability.
Yeah.
It represents this strange modern area of a law where the triangle entirely collapses and the government just does not care about the guilty mind at all.
Oh, wow. Okay, well, we will definitely explore the mechanics of that bubble a bit later.
Yes, we will.
Okay, let's unpack this. The physical act seems like the most logical place to start building our triangle. Point number 1. Because, a fundamental rule of our legal system is that the government cannot punish a person simply for sitting on their couch and having a terrible, violent thought.
And that is a crucial protection against government overreach. We do not police the imagination.
Thank goodness for that.
Right, a dark thought, a malicious fantasy, or just a secret desire standing alone can never trigger criminal liability. The law requires a manifestation of that thought in the real world.
Okay.
So the core requirement is that the actus reus, that first point, must be a physical, voluntary movement.
Physical and voluntary. Okay, let's put those two concepts apart, starting with the physical requirement. Because when I think of a physical act in a criminal context, I immediately picture obvious muscular movements,
Like what?
like someone throwing a punch or using a crowbar to break a door or running away with a stolen laptop. But the law defines physical act much more broadly than just athletic movements.
Right. Oh, much more broadly. A physical act is simply an affirmative action taken in the real world that changes the environment, however slightly.
Okay, so give me an example of something small.
Well, a prime example is speech.
Wait, really? Just talking?
Yes. Using your vocal cords to speak words is a physical act that can satisfy that very first point of our triangle.
So vibrating my vocal cords can legally be the equivalent of throwing a punch? I assume we're talking about crimes where the words themselves are essentially the weapon.
Extortion is the perfect illustration of this.
Extortion, which is basically blackmail, right?
Exactly. If a person threatens to reveal a devastating secret about someone, unless they're paid a large sum of money, no one has been physically touched.
Right.
No property has been violently taken, but the verbal threat constitutes the physical act. The speech is the crime.
Oh, that makes total sense.
And the same logic applies to solicitation, where the act of asking someone else to commit a crime is the physical violation.
Okay, so words count. But looking at the outline, it also lists possession as a physical act. And this feels a bit counterintuitive to me.
How so?
Well, if I'm just standing on a street corner with an object in my pocket, I'm not actively doing anything, my muscles are at rest. How does a lack of movement qualify as an affirmative physical act?
It's a great question. The law treats possession as an act because you are exerting control over an object. You're maintaining dominion over it.
Okay.
However, because it is a passive state, the Model Penal Code, which we'll just call the MPC from now on, given how heavily it's tested.
Right. The exam loves the MBC.
It really does. So the MPC puts strict boundaries around when possession truly counts as a criminal act. The MPC requires that the possession be conscious and that the defendant have control for a sufficient period of time.
Okay, wait. Let me test that boundary with a hypothetical because this feels very much like an MBE question.
Let's hear it.
Let's say I am at a crowded party. I decide to leave, so I go to the bedroom, grab what looks like my jacket off the bed, and put it on. 2 seconds later, I put my hands in the pockets to look for my keys, and my fingers brush against a small plastic bag. Right. I pull it out, look at it, and realize it's a bag of illegal narcotics. The jacket wasn't mine. At that exact fraction of a second, the police kick the door down, freeze the room, and see me holding the drugs.
This is a classic law school trap.
Really? Because it looks pretty bad for me.
The prosecutor will argue that you were physically holding illegal contraband when the police arrived. The physical reality is undeniable. But under the MPC rules for possession, you have a strong defense that you did not commit a voluntary act.
Okay, so the defense would focus on the timeline of my knowledge, right? Because when I first put the jacket on, I had absolutely no idea the drugs were there.
Exactly. The first requirement for possession is conscious knowledge of the object. While the jacket was on the bed and while it was on your back before you checked the pockets, you lacked conscious knowledge. So during that period, there was no physical act of possession in the eyes of the law.
But the moment I pulled the bag out and looked at it, I acquired conscious knowledge. I knew I was holding drugs.
You met the first requirement at that precise second. But the MPC demands a second element, which is the key to solving this exam question. The defendant must be aware of the control for a sufficient period of time to be able to terminate the possession.
Meaning, I need enough time to throw it on the floor or hand it to someone else.
Precisely. The law recognizes that it takes a moment for the brain to process unexpected information and send a signal to the body to react. In your scenario, the police breached the room at the exact second of discovery.
So I was trapped.
Right. You had conscious knowledge, but you were deprived of the opportunity to terminate your control. Therefore, the passive state never ripened into a voluntary physical act of possession.
Okay, that is a vital distinction for you to memorize. Knowledge alone is not enough for possession. It must be knowledge paired with the physical opportunity to abandon the object.
Exactly.
So if the fact pattern shows an immediate arrest upon discovery, the first point of the triangle fails. Which brings us to the second half of the requirement. Voluntariness. The act must be physical, and it must be voluntary.
And the principle here is that the conduct must be the product of the person's own determination. The conscious mind must direct the physical body to move.
Right.
If the body moves without a command from the conscious mind, the resulting harm is viewed as a tragic accident of nature, not a crime.
So sleepwalking is the standard example of an involuntary movement, right? If someone with a severe sleep disorder walks out of their house in the middle of the night, completely unconscious, and knocks over a neighbor's expensive mailbox, they didn't commit a voluntary act.
That's right. And reflexes operate on the exact same logic.
Like at the doctor's office.
Yes, if a doctor taps a patient's knee with a medical hammer and the patient's leg violently kicks outward, striking a nurse, the patient is not criminally liable for battery. The movement completely bypassed the conscious decision-making centers of the brain. It was a purely neurological reaction.
Okay, what about physical force applied by a third party? Imagine I'm standing on the edge of a subway platform. The platform is packed with commuters. Suddenly, the person behind me violently shoves me in the back.
Okay.
The force propels me forward, and I crash into a bystander, knocking them onto the tracks. My physical body hit the bystander, but my brain certainly didn't choose to do it.
In that scenario, you are effectively a projectile.
A projectile. I like that word for this.
You're an instrument being used by the person who shoved you. The person who initiated the shove committed the voluntary physical act. You were deprived of any physical agency. You cannot be held responsible for the resulting harm because your movement lacked volition.
Okay, those examples are straightforward.
Yep.
But, the bar exam rarely tests the straightforward scenarios.
Never.
Right? They will look for the gray areas where a seemingly involuntary act is actually hiding a voluntary choice. And I know the outline highlights the epileptic driver scenario as a primary example of this trap.
What's fascinating here is it's a brilliant mechanism for testing a student's ability to analyze a timeline.
Okay, walk us through it.
Consider this fact pattern. A person has a documented medical history of severe epilepsy. Their doctor has warned them that their seizures are unpredictable and cause a total loss of motor control.
Okay, so they know the risk.
Despite fully understanding this diagnosis, the person decides to get into their vehicle, start the engine, and merge onto a busy highway. While traveling at high speed, they suffer a massive seizure.
Oh, no.
Their body goes completely rigid, their foot forcefully depresses the accelerator, the car veers into a crosswalk, and a pedestrian is killed.
Wow. Okay, so if I'm sitting in the exam room reading that, my immediate instinct is to focus on the exact moment of impact. The prosecutor wants to charge them with vehicular homicide or manslaughter.
Right.
And at the moment the car struck the pedestrian, the driver was unconscious, their body was experiencing a medical convulsion. The foot pressing the pedal was an involuntary neurological reflex, literally identical to the knee tap at the doctor's office.
That's how it looks, yes.
So the defense attorney will argue there was no voluntary act, and the triangle collapses.
The defense attorney will certainly make that argument, but they will lose. The driver is criminally responsible.
Wait, really? Walk me through the legal reasoning. How can a judge rule that a seizure is voluntary?
Well, the judge does not rule that the seizure itself was voluntary. The legal mechanism here is that the court expands the timeline.
Oh, they look backwards.
Exactly. The law doesn't require the very last physical movement before impact to be voluntary. It requires that the chain of events was set in motion by a relevant voluntary act. The court looks backward in time, prior to the seizure.
I see. So the voluntary act was making the conscious choice to operate a heavy machine while knowing the profound medical risk.
Exactly. The driver consciously walked to the car, voluntarily put the key in the ignition, and voluntarily steered onto the highway. Because they had prior knowledge of their condition, the law views the decision to drive as the voluntary act that created the foreseeable risk of death. The subsequent involuntary seizure doesn't break the chain of liability because the dangerous situation was voluntarily initiated.
Okay, let me add a twist to that hypothetical to test the boundaries. What if the driver had suffered from epilepsy years ago, but their neurologist recently declared them completely cured and authorized them to drive?
Okay, big difference.
Right. And then, completely unexpectedly, they suffer a relapse seizure on the highway and hit the pedestrian.
That changes the outcome entirely. In your altered scenario, the decision to drive was still a voluntary physical act, but it was no longer a criminal or reckless act because the driver lacked knowledge of the danger.
Because the doctor said they were fine.
Right. The driver reasonably believed they were safe to operate a vehicle based on expert medical advice. The sudden seizure truly was an unforeseeable medical event, rendering the crash an involuntary accident.
That perfectly illustrates how the examiners test the nuance. They aren't just asking, is a seizure voluntary? They're asking, did the defendant voluntarily create the environment where the seizure would cause harm?
You have to look at the whole timeline.
Right, the entire context of the event, not just the split second of impact. Okay, so we have established that a crime demands an action, a voluntary movement of the body. But that raises a really fascinating counter question. What happens when a person does absolutely nothing? Can the total absence of physical movement satisfy the first point of our triangle?
You're asking about criminal omissions, the failure to act. This area of law feels deeply unnatural to many people because it often conflicts with our basic moral instincts.
Let's explore the general rule first before we look at the exceptions. If I'm just standing on a public sidewalk, minding my own business, and I witness a dangerous situation unfold, do I have a legal obligation to intervene?
Under the general principles of Mexican criminal law, the answer is a definitive no.
Really? None at all?
There is no broad general legal duty to rescue a stranger in peril. You can be walking by a shallow pond, see a person struggling in the water, and recognize that you could easily save them without any risk to yourself. Morally, society expects you to help. But legally, you are permitted to stand on the shore, watch the person drown, and do absolutely nothing. You are a mere bystander.
That is a staggering reality. It feels incredibly callous. A prosecutor couldn't charge me with anything.
A prosecutor would have no foundation for a case. If you played no role in putting the victim in the pond and you have no special relationship with them, the law views your inaction as legally neutral.
That's why.
The legal system is hesitant to force citizens to become heroes under threat of imprisonment. Doing nothing is not a crime for a mere bystander.
However, the law cannot operate in absolutes. There must be situations where society demands action, where doing nothing is treated as the equivalent of a physical attack.
Yes, there are specific narrow exceptions. The law identifies exactly 5 situations where a legal duty to act is imposed.
Okay, 5 situations.
If a person falls into one of these 5 categories, they are stripped of their bystander status. If they fail to act, their omission replaces the physical act requirement on our mind map. Their deliberate inaction becomes the actus reus.
5 specific exceptions. This is prime material for an MBE multiple choice question. The examiners love lists of 5. Let's break down each duty, examining why the law imposes it, starting with the first exception.
The first duty is created by statute.
Statute, so a written law.
Right. This is the most straightforward exception because the legislature has explicitly written a law demanding an affirmative action. The classic example is the legal obligation to file an income tax return.
Oh, taxes. Right.
You do not physically attack the revenue agency when you evade taxes. You simply fail to submit a document. But because the statute mandates the action, your omission is a criminal offense. Another common statutory duty is the requirement to report a traffic accident if you're involved in a collision.
Okay, so if the written law says you must, then doing nothing is a crime. That is the statutory duty. What is the second situation that forces a person to act?
The second duty arises through a contract. If a person voluntarily signs an agreement and accepts compensation to protect or care for someone, they have legally bound themselves to act when danger arises.
So paid to care.
Consider a lifeguard hired by a municipality to watch a public beach. The lifeguard is being paid specifically to monitor the water and intervene if someone is drowning.
Okay, so if the lifeguard sees someone struggling, decides they're too tired to swim, and just sits in their chair watching the person drown, their failure to act is criminal.
Precisely. Their contract created a legal duty of care. A bystander on the same beach can watch and do nothing, but the lifeguard's contract transforms their omission into a crime, potentially manslaughter or even murder, depending on their mental state.
Wow.
The same principle applies to a hired nurse or a professional nanny who fails to provide essential nourishment to a dependent patient or child.
Okay, so we have statute and contract. What is the third exception?
The third duty is based on a special relationship. The law recognizes that certain biological and legal bonds inherently create a duty to protect, regardless of whether a contract was signed.
Like family.
Exactly. The most heavily tested relationships are the duty a parent owes to their minor child and the duty spouses owe to one another.
So if a parent is walking down the street with their toddler
Mm.
and the child wanders toward a busy intersection, the parent cannot simply watch them walk into traffic.
No. The parent has an absolute legal duty to attempt to intervene or call for help. Their biological and legal status as a parent imposes an automatic obligation to protect the child from foreseeable harm. If the parent does nothing, their omission is a criminal act.
Let me pose a nuanced scenario here. Let's return to the off-duty lifeguard.
Okay.
The lifeguard is not at the beach where they work. They're sitting in their own backyard. They see a child fall into the neighbor's pool. Because they're off the clock, their contractual duty does not apply. Does a special relationship apply because they have the physical skills to save the child?
No. Having the skill to rescue someone does not create a special relationship under the law.
Really?
Yes. Unless the lifeguard is the parent of the child or has formally assumed guardianship, they revert to the status of a mere bystander when they are off duty. They can legally watch the tragedy unfold from their yard without criminal liability.
That really highlights how formal these duties are. Skill and proximity do not equal a legal duty. Okay, the fourth exception sounds a bit more complex. The outline calls it a detrimental undertaking.
It's a complex name for a very logical concept. It occurs when a bystander voluntarily decides to intervene, but in doing so, they make the situation worse, or they isolate the victim from other potential rescuers and then they abandon the effort.
Walk me through the mechanics of that. How does trying to help turn into a criminal omission?
Imagine a person collapses on a crowded city sidewalk suffering a heart attack. Dozens of people are walking by. Remember our baseline rule. Every single person on that sidewalk has the legal right to ignore the victim and keep walking.
Like the bystander rule.
But let's say one pedestrian decides to stop. They kneel down and loudly announce, "I am going to help. Everyone stand back."
So by taking charge, they're essentially telling the rest of the crowd that the situation is handled. The crowd disperses. No one else calls an ambulance because they assume the rescuer is doing it.
Exactly. The rescuer has now isolated the victim. Now, imagine the rescuer drags the victim into a nearby alley for privacy, realizes they do not actually know CPR, decides the situation is too stressful, and quietly walks away, leaving the victim hidden in the alley.
Oh, wow. So they took a person who was in a public space where someone eventually would have called for medical help, moved them to a hidden location, and abandoned them. They actively worsened the victim's chances of survival.
That is the detrimental undertaking. The law states that once you voluntarily begin a rescue and you alter the circumstances in a way that deters others from helping, you have assumed a legal duty to see the rescue through to a reasonable conclusion.
So you're locked in.
You must either finish the assistance or ensure the victim is handed over to competent authorities like paramedics. You lose the right to simply walk away.
You cannot half-rescue someone into a worse position. That leaves the fifth and final exception to the bystander rule.
The final duty is causation, also known as the creation of peril. If your actions caused the dangerous situation in the first place, you possess an absolute duty to try and mitigate the harm, even if the initial act was entirely accidental and non-criminal.
Give me an example of an accidental creation of peril.
Suppose you are hiking in a dry forest. You stop to eat lunch and accidentally knock your camp stove over, igniting some dry leaves. You did not intend to start a forest fire. It was a pure accident.
Right.
However, because your physical action created the peril, you cannot simply pack your bag and hike away. You have a legal duty to attempt to extinguish the fire, or at the very least, immediately notify the fire department.
Because I caused the danger, the burden of solving it falls on me. If I walk away, the failure to report the fire becomes the criminal act. Okay, let's summarize this for your mind map. The general rule is you can do nothing. But there are 5 exceptions where inaction equals a physical act. 1. Statute the written law demands it. 2. Contract you are compensated to care. 3. Special relationship parent to child, spouse to spouse. 4. Detrimental undertaking, you intervene, isolate the victim, and abandon them. And 5. Causation, you accidentally created the danger.
If the listener encounters an MBE question featuring 2 people standing near a dying victim doing nothing, that is the examiner waving a giant flag.
A trap.
A huge trap. The question is testing these 5 exceptions. The professor is not asking you to treat both bystanders identically. One of those people has a hidden duty. Look closely at the facts. Is one of the bystanders the victim's spouse? Did one of them accidentally push the victim? Identify the duty, and you identify which person will be charged with a crime.
That is a phenomenal analytical shortcut for the exam. Find the hidden duty. Okay, so we have thoroughly explored the first point of our triangle. We understand the physical body, both the affirmative movements and the criminal omissions. Now we must transition to the most difficult area of criminal law.
The dark room.
Right. We are leaving the observable physical world and moving into the invisible space of the mind. Point 2 of our mind map. the mens rea or the guilty mind?
This is where the analysis becomes highly theoretical. Except for our isolated bubble of strict liability, the physical act is meaningless without a corresponding mental state. And crucially, the act and the mind must occur simultaneously. The intent must drive the action.
To understand the guilty mind for the bar exam, we have to navigate two entirely different legal systems. We have the traditional common law, which evolved over centuries in England and the early United States, and we have the modern model penal code. The MBE tests both. So let's begin with the common law structure.
The common law attempts to categorize human intent by placing it into three distinct buckets. Specific intent, general intent, and malice. These labels determine what the prosecutor must prove about the defendant's internal thought process.
Let's unpack the first bucket. Specific intent. The name suggests highly focused mental state. It sounds like the defendant is not just reacting to a situation, but actively scheming.
That is the correct way to conceptualize it. Specific intent requires that the defendant possess a subjective desire, a specific objective, or a master plan to accomplish a prohibited result.
A master plan.
Right. They are not merely intending to perform the physical movement, their mind is focused on the ultimate consequence of that movement.
The outline provides throwing a punch as a foundational example to distinguish these mental states. Let's explore that.
If a person becomes enraged during an argument and swings their fist at another person's face, their brain intended the physical movement of their arm. They wanted to strike the person.
Simple battery.
But what if they swing their fist with the explicit goal of knocking the victim unconscious so they can remove the victim's wallet and steal their cash?
In the second scenario, the physical act is identical, a swinging fist. But the mental state is completely different. The punch is merely a tool being used to achieve this specific objective of theft.
Exactly. The first scenario is a basic assault or battery. The second scenario elevates the crime because the defendant acted with the specific intent to permanently deprive the victim of their property. They had a further calculated objective.
Now, memorizing which crimes fall into this specific intent bucket seems daunting. The common law has dozens of offenses. How is a student supposed to remember which ones require a master plan?
Fortunately, generations of law students have relied on a very effective mnemonic device, which is highlighted in the provided outline. The listener should write this directly on their mind map next to the mens rea point. The mnemonic is FIAT, FIAT.
FIAT. Let's decode that letter by letter. These are the specific intent crimes. What does the F stand for?
F stands for first-degree murder. This is not a spontaneous crime of passion. First-degree murder requires premeditation and deliberation. The defendant must have formed the specific, conscious intent to end a human life before taking action.
The master plan to kill. Got it. What does the I represent?
I represents inchoate offenses. Inchoate is a formal term for incomplete crimes. This category includes attempt, solicitation, and conspiracy.
Let's pause on that. Why do incomplete crimes require specific intent?
Think about the logic of an attempted crime. If a person shoots a gun at someone but misses, the physical result of murder never happens. To punish them for attempted murder, the court must prove that their specific subjective goal was to cause death, even though they failed.
Right, because you can't accidentally try to do something.
Exactly. You cannot accidentally attempt to do something. The very concept of an attempt requires a specific objective. Similarly, conspiracy requires a specific intent to agree to a plan and a specific intent to see that plan executed.
That makes perfect sense. The lack of physical result means the mental state has to carry the entire weight of the crime. So F is first-degree murder. I is inchoate offenses. What is A?
A is assault with intent to commit a battery. An ordinary assault can sometimes be committed just by acting recklessly and scaring someone. But this specific type of assault requires a prosecution to prove that the defendant's actual subjective goal was to physically strike the victim.
And finally, the letter T.
T stands for theft offenses. This is a massive umbrella category. It covers larceny, burglary, robbery, embezzlement, forgery, and false pretenses. In all of these crimes, the physical taking of the item is not enough. The defendant must possess the specific intent to permanently deprive the rightful owner of their property.
FIAT. FIAT. First-degree murder, inchoate, assault with intent, and theft. You really must memorize that list. But let me ask, why is the distinction so important? Why does the defense attorney care so deeply whether their client is charged with a specific intent crime versus a general intent crime?
It changes the entire landscape of the trial because Specific intent crimes open the door to unique legal defenses. The most prominent example is voluntary intoxication.
Meaning the defendant chose to consume massive amounts of drugs or alcohol.
Correct. If a person becomes severely intoxicated and commits a basic general crime like getting into a bar fight and committing battery, their drunkenness provides zero legal protection.
The law essentially says you chose to drink, you accept the consequences of your reckless behavior.
Exactly. But if they are charged with a crime from the FI At list, say burglary, which is a theft offense,
The dynamic changes.
the dynamic changes completely because burglary requires a highly focused, complex master plan. The specific intent to break into a structure to commit a felony inside a defense attorney can argue that the defendant was so profoundly intoxicated that their brain was chemically incapable of forming that specific intent.
Oh.
They might argue the defendant was too drunk to know whose house they were in, let alone formulate a plan to steal. If the jury believes the intoxication negated the specific intent, the defendant cannot be convicted of burglary.
That is a staggering legal mechanism. Voluntary intoxication can actually act as a shield, but only for the FI Act crimes. That perfectly illustrates why memorizing that list is non-negotiable for the exam. Okay, let's move to the second bucket of the common law mental state. General intent.
General intent is much less demanding for the prosecution. It simply requires proving that the defendant intended to perform the physical act that the law prohibits. The defendant does not need a grand master plan, and they do not necessarily need to intend the final disastrous result. They just have to voluntarily engage in the prohibited conduct.
Returning to our earlier example, if someone gets angry and punches a wall in a crowded room, but their fist misses the wall and hits a bystander.
That is a general intent battery. The defendant intended the physical motion of forcefully swinging their arm in a crowded space. They did not have the specific intent to steal, nor did they necessarily have the specific goal of injuring that exact bystander. But they intended the unlawful physical action, and that is sufficient for general intent.
So things like rape, kidnapping, and false imprisonment fall under this.
Yes, those are all general intent crimes.
This raises an important distinction that students often confuse. The outline emphasizes that motive is not the same as intent. How do we separate those concepts clearly?
Intent addresses what the defendant was trying to accomplish physically in that exact moment. Motive explains why they wanted to accomplish it. In criminal law, the prosecution must prove intent. They are almost never required to prove motive.
Let's use a classic moral dilemma to illustrate that. A parent steals a loaf of bread from a wealthy grocery store to feed their starving child.
The motive is deeply sympathetic. The motive is love, desperation, and survival. But the intent is entirely separate. At the moment the parent placed the bread in their coat, did they possess the specific intent to permanently deprive the grocery store of its property? Yes. Therefore, the mens rea for larceny is fully satisfied.
The jury might feel terrible for the parent, and the judge might offer a very light sentence because of the sympathetic motive, but the legal guilt remains. The motive is the backstory. The intent is the psychological reality at the moment of the act.
Okay.
So specific intent, the master plan, and general intent, the intended physical movement. The final common law bucket is malice.
Malice is a term that causes endless confusion because its legal definition is entirely different from its everyday definition. In normal conversation, malice implies hatred, evil, or a desire for revenge. But in criminal law, specifically for the crimes of common law, murder and arson, malice means a reckless disregard of a substantial and unjustifiable risk.
It sounds like an extreme form of dangerous carelessness. The defendant doesn't necessarily want the bad result to happen, but they are playing a game of Russian roulette with other people's safety.
That is an excellent analogy. Let's look at arson. Imagine a homeowner decides to burn a pile of dry brush in their backyard. They live in a dense neighborhood, the houses are close together, and it is a notoriously dry and windy day. The homeowner does not have a specific master plan to burn down their neighbor's house. They don't hate their neighbor.
So there is no specific intent to commit arson.
Right. But lighting a large fire in those specific dangerous conditions demonstrates a reckless disregard for an obvious and high risk that the fire will spread. If the wind catches an ember and the neighbor's house burns down, the homeowner acted with malice. They recognized a massive risk and chose to proceed anyway. The law treats that extreme risk-taking as a substitute for a specific desire to cause harm.
Specific intent, general intent, malice. Those are the three common law tools the prosecution uses to prove the guilty mind. But the exam loves to present scenarios where the defendant's mental state is clear. But the physical world refuses to cooperate with their plan. The physical result goes sideways.
You are leading us into the fascinating doctrine of transferred intent. It addresses the reality that criminals are frequently incompetent or unlucky.
Let's build a scenario. Defendant D is standing on a city street. D looks across the road and sees person a business rival they despise. D pulls out a handgun, takes careful aim, and forms the specific intent to murder person A. D pulls the trigger. But D is a terrible shot. The bullet misses person A completely, travels down the block, and strikes person B, a completely innocent bystander waiting for a bus. Person B is killed instantly.
We have a shattered mind map here. The physical act was pulling the trigger. The causation is the bullet killing person B. But the mental state, the specific intent to kill, was entirely focused on person A. Defendant D had no malice, no intent, and no knowledge regarding person B. So how do you charge defendant D with the murder of person B?
Well, the defense attorney would argue that you can't. They would say D had no mens rea toward the actual victim, therefore the triangle is incomplete.
And that is where the law intervenes with the legal fiction. We use the doctrine of transferred intent. I find it helpful to visualize this concept as a bouncing laser beam.
I love that visual. Walk us through how the laser beam operates.
Imagine the defendant's specific intent to kill is a powerful red laser beam projecting out of their mind. Defendant D aims that intent laser directly at person A. The intent is locked on, but the physical bullet misses. The law refuses to let the defendant escape liability for a death just because they have bad aim. So the legal system takes that mental laser beam, bounces it off the intended target, person A, and transfers it directly onto the physical body of the actual victim, person B.
So the intent detaches from the original target and follows the physical harm.
Exactly. The law says you possess the required mental state to murder a human being, and a human being died as a direct result of your physical actions. The fact that the universe substituted a different victim is irrelevant to your culpability. Defendant D is fully guilty of the murder of person B through transferred intent.
That is a brutal but logically necessary rule. It prevents criminals from using their own incompetence as a shield. But wait, what happens to person A? The original target survived, but they were still shot at.
Defendant D's legal troubles are compounded. Because D possessed the specific intent to murder person A and took a substantial step toward completing that goal by firing the weapon, D is also guilty of the attempted murder of person A.
Wow. So by missing the target, the defendant doubled their criminal liability. They face a completed murder charge for the bystander and an attempt charge for the rival. Now, let me present a variation of this scenario to test a very specific MBE trap. What if the error is not in the physical aim, but in the defendant's perception?
Let's hear the variation.
It is midnight. Defendant G is waiting in a poorly lit parking garage, holding a gun, waiting for person A. A figure walks out of the elevator wearing a distinctive trench coat and hat that person A always wears. Defendant D looks at the figure, is absolutely certain it is person A, aims carefully, and fires. The bullet hits the figure perfectly in the chest. The person dies. When the police arrive, they discover it was actually person B who had just borrowed the coat. Does D's intent transfer from A to B?
A phenomenal question, and the answer is no. Transferred intent does not apply to this scenario at all.
Wait, why not? The wrong person died, just like in the first scenario.
The outcome is similar, but the mechanics are entirely different. The first scenario was the case of bad aim. The physical bullet went somewhere different than the intended target. Your new scenario is a case of mistaken identity. Defendant D's aim was perfect.
Oh, I see.
D looked at a physical human body standing in the garage, aimed at that exact body, and the bullet hit that exact body. The intent laser beam went exactly where D wanted it to go.
D just had the wrong name attached to the target in his mind.
Exactly. D intended to kill the human being standing in front of him, and he succeeded. There is no need to transfer the intents because the intent directly connected with the physical result. D is guilty of the murder of B through direct intent. The mistake regarding the victim's identity is legally irrelevant to the mens rea of murder.
That is a vital distinction for you to note. Bad aim requires the transfer fiction. Mistaken identity does not. Okay, let's discuss one more crucial limitation on this doctrine. Does the bouncing laser beam ever run out of energy? What if no one dies?
The primary rule to memorize for the exam is that transferred intent only applies to completed crimes resulting in physical harm. It is never used to manufacture an attempt charge for the unintended victim.
Let's return to the street corner. D shoots at A, misses A entirely. The bullet flies toward bystander B. But instead of hitting B in the chest, the bullet just barely grazes B's arm. It is a minor scratch. B survives easily.
Let's analyze the charges. D intended to kill A, took the shot, and failed. D is guilty of the attempted murder of A. Now, what about B? The physical result on B is a minor injury, so the intent to cause unlawful physical contact transfers to B, making D guilty of battery against B.
But what if the prosecutor wants a heavier charge? The prosecutor argues D had the specific intent to kill and that intent laser beam bounced onto B. Therefore, D should be charged with the attempted murder of B as well.
The judge will reject that argument. The law only allows the intent to transfer to match the actual completed physical harm. Since B did not die, the intent to kill cannot transfer. You cannot transfer an intent to create an attempted crime against someone you never meant to target. The laser beam starts bouncing if the ultimate harm is not realized. D is only guilty of battery regarding the bystander.
Okay, we've spent considerable time in the common law weeds. Specific intent, FI8, malice, and the bouncing laser beam. But as we noted earlier, the MBE also tests the modern approach, the model penal code. And the drafters of the MPC looked at all these common law buckets and decided they were fundamentally flawed.
Yes, the drafters believed the terms specific intent and general intent were too vague and led to inconsistent court rulings across different states. They wanted a cleaner, more scientific approach to the human mind. So they abolished the old buckets and replaced them with a strict hierarchy of mental states.
I picture the MPC system as a four-step staircase. You start at the top, which represents the highest, most culpable level of evil intent, and you walk down the steps to lower levels of fault. Let's start at the very top, step 1.
The highest level of fault under the MPC is acting purposely. In plain English, a person acts purposely when it is their conscious object to engage in the conduct or cause the result. It is their primary goal. It is what they want to happen.
This sounds very similar to the old specific intent master plan. If I carefully measure out poison and mix it into my wealthy uncle's tea because I desperately want him to die so I can inherit his estate, I am acting purposely. My conscious goal is his death.
Exactly. You are operating at the peak of criminal culpability. Now, let's take one step down the staircase to step 2. Acting knowingly.
Knowingly feels like a very subtle shift. How does it differ from purposely?
A person acts knowingly when they do not necessarily desire the bad result as their primary goal, but they are practically certain that their conduct will cause the result. They know the harm is an unavoidable side effect of their plan, and they choose to proceed anyway.
I need an analogy to firmly separate the two. They blend together easily.
Let's use a dramatic scenario. An executive owns a private, mid-sized corporate jet. The executive's company is failing, and they desperately need the massive insurance payout tied to the aircraft. The executive constructs a time bomb and places it in the cargo hold of the plane.
Okay.
The executive knows the company pilot will be flying the plane alone over the ocean when the timer reaches 0.
So the primary objective is the destruction of the property for financial gain.
Correct. The executive's conscious object is to destroy the plane. Therefore, they are acting purposely regarding the destruction of property. But what about the pilot? The executive has no personal animosity toward the pilot. They don't specifically desire the pilot's death. In fact, they might feel terrible about it. The pilot's death is not the primary goal.
However, the executive is practically certain that a bomb detonating at 30,000 feet will result in the pilot's death. It is an unavoidable physical reality.
Precisely. Because they are practically certain the death will occur, the executive acts knowingly regarding the murder of the pilot. The law views proceeding in the face of absolute certainty as only marginally less culpable than desiring the outcome directly.
Purposely is the conscious goal. Knowingly is practical certainty of the side effect. We are halfway down the staircase. Let's step down to step 3, acting recklessly.
We encountered a version of this with common law malice. A person acts recklessly when they consciously disregard a substantial and unjustifiable risk. The crucial element here is awareness. The defendant must subjectively realize that their actions are incredibly dangerous, but they choose to ignore the risk and roll the dice anyway.
It is the ultimate expression of dangerous indifference. If I decide to test the top speed of my sports car by driving 120 miles per hour through a dense residential neighborhood while children are playing on the sidewalks, I don't want to hit anyone. My goal is just to drive fast. I'm not practically certain I will hit someone, but I am fully aware that the risk of a catastrophic accident is enormous, and I simply don't care.
That is textbook recklessness. You are consciously disregarding a risk that a law-abiding citizen would never take. Now, let's move to the final, lowest step on the MPC staircase, acting negligently.
In everyday conversation, being negligent just means being careless or sloppy. Forgetting to lock the front door. How does the criminal law define negligence?
The dividing line between reckless step 3 and negligent step 4 is all about the defendant's internal awareness. With recklessness, the defendant perceived the risk and ignored it. With negligence, the defendant did not perceive the risk at all. They were completely unaware of the danger they were creating.
Wait, if the person didn't know they were being dangerous, how can the government throw them in jail? Isn't the whole point of mens rea to punish a guilty mind? A clueless mind isn't necessarily guilty.
The law justifies punishing negligence by using an objective standard. The jury asks, would a reasonable person in the defendant's exact situation have recognized the risk? If the risk was so obvious that any normal person would have seen it, the defendant's failure to perceive it is considered a gross deviation from the standard of care. Their sheer ignorance and carelessness become the source of fault.
So, purposely is the conscious goal. Knowingly is practically certain. Recklessly is aware of risk and ignored it. And negligently is unaware of risk but should have known. That is a clean, logical system.
Yeah.
But how does this play out practically on the bar exam? Why arrange them as a staircase?
The staircase visual is crucial because of the MPC's hierarchy rule. This rule is a major shortcut for answering exam questions. Suppose a criminal statute reads, "It is unlawful to knowingly transport stolen goods across state lines." The statute demands a mental state at step 2. Knowingly. At trial, the prosecutor introduces overwhelming evidence proving that the defendant acted purposely, step 1. The defense attorney stands up and argues, "Your Honor, the statute requires the prosecution to prove my client acted knowingly. They failed to do that. They proved he acted purposely. The evidence doesn't match the statute. Case dismissed."
That sounds like a ridiculous argument. Proving a higher level of guilt should automatically cover a lower level.
You are applying the hierarchy rule instinctively, and the MPC formally codifies it. Proving a higher mental state on the staircase always satisfies a lower statutory requirement. If the law requires recklessness and the prosecutor proves knowledge, the burden is met. The greater fault encompasses the lesser fault.
So what does this all mean for the exam? It's a great mechanical rule. If the facts show the defendant being highly calculated, they will satisfy any lower intent requirement the question throws at them. There's one more MPC rule we need to cover. What happens if the legislature writes a terrible statute and forgets to include a mental state entirely?
This happens frequently in the real world. A statute might simply say it is a felony to damage municipal property. It doesn't say purposely damage or recklessly damage.
Under the common law, courts would spend years arguing about what the legislature intended. What does the MPC do?
The MPC provides a hard-coded default setting. If a statute defines a crime but fails to specify the required culpability, the default mental state is always recklessly. The prosecution must prove the defendant acted with at least a conscious disregard of a substantial risk. They cannot convict the person just for being negligent.
Default equals reckless. That is a solid flashcard fact to memorize. Okay, we have now spent significant time analyzing how the act and the mind must connect. We've explored the common law buckets and the MPC staircase. Now we must turn our attention to that strange, detached bubble we drew on our mind map at the very beginning of the deep dive.
It is time to discuss strict liability and its close cousin, vicarious liability. This is the area of criminal law where everything we just learned about the guilty mind is violently thrown out the window.
Our fundamental rule for the last 40 minutes has been act plus mind equals crime. Strict liability shatters that equation.
Completely. A strict liability offense has absolutely no mens rea requirement. It does not matter if the defendant acted purposely, recklessly, or if they were the victim of a completely unforeseeable, innocent accident. If their physical body committed the prohibited act, they are legally guilty. The inquiry ends there. The prosecutor never has to prove what was in their head.
That feels deeply un-American. It strips away the fundamental fairness of considering a person's intent. Why would the legal system permit the government to imprison someone who made an honest, blameless mistake?
It is a harsh doctrine, but it is driven by modern industrial society and public policy. Strict liability is almost exclusively applied to public welfare offenses.
What does that mean exactly?
The rationale is that certain commercial activities or regulated industries are so inherently dangerous to the public or so vital to public health that society cannot afford to care about the defendant's state of mind. The burden of absolute perfection is placed on the person engaging in the activity.
The danger is so high that the law says you must get this right 100% of the time or face the consequences. What are the standard examples tested on the exam?
The most common example involves the sale of alcohol to minors. If a bartender serves a beer to a 19-year-old, the bartender has committed a strict liability offense.
even if the kid had a great fake ID.
It is completely irrelevant if the 19-year-old presented a highly sophisticated forged identification card. It doesn't matter if the teenager looked 30 years old and the bartender honestly and reasonably believed they were of legal age. The mental state is irrelevant. The physical act of the sale is the entirety of the crime.
By imposing strict liability, the state forces bars to be obsessively paranoid about checking IDs because there is no "I made a reasonable mistake" defense available.
Exactly. Statutory rape is another primary example designed to offer maximum protection to minors by removing any defense regarding a mistake of age. On a larger scale, strict liability governs environmental regulations and food safety laws.
Like factory pollution.
Yes, or if a massive food processing plant accidentally ships out a batch of contaminated meat due to a microscopic failure in a machine, the corporation and its executives can face criminal charges. It doesn't matter that they spent millions on safety protocols and had no knowledge of the contamination. The public's right to safe food overrides the executive's lack of intent.
The public welfare demands absolute accountability. Okay, from an exam strategy perspective, how does a student identify a strict liability crime? Exam questions often feature made-up, hypothetical statutes. How do I know if I need to analyze the mens rea or if I should just look at the physical act?
It requires careful statutory interpretation. You must look for two specific clues. Clue number one is the explicit language of the statute. If you read the text and it completely lacks any mental state words, there is no knowingly, willfully, with intent to, that is a strong indicator the examiners are testing strict liability. It will just read whoever sells or whoever transports.
The naked physical act. But you said there were two clues.
Clue number two is often more definitive. Look at the severity of the punishment attached to the crime. Because strict liability is so inherently harsh, courts are highly reluctant to apply it to serious felonies. If the hypothetical statute imposes a minor penalty, a $500 fine, or a small administrative fee, courts will easily interpret it as strict liability.
But what if the statute imposes a 10-year prison sentence and it doesn't mention a mental state?
If the penalty is severe deprivation of liberty, a judge will almost always read a mens rea requirement into the statute, even if the legislature left it out. The Supreme Court has repeatedly signaled that serious criminal stigma and long prison terms require proof of a guilty mind. So, small fine equals strict liability. Heavy prison time implies a mental state requirement.
That is a phenomenal practical tip for breaking down a statute on the MBE. Now, that covers strict liability, where you did the act but lacked the mind. What about vicarious liability? Strict liability means you didn't have a bad mind, but what if you didn't even do the act?
Vicarious liability is arguably even more extreme than strict liability. With strict liability, the defendant still committed the physical act. With vicarious liability, the defendant is punished for an act they did not physically commit and for a mental state they did not possess. They are held criminally responsible for the actions of a completely different human being.
How is that constitutional? How can I be charged for someone else's crime?
It relies entirely on relationships of authority and control, primarily in the corporate and employment context. The law establishes that an employer can be held vicariously liable for the regulatory crimes committed by their employees, provided the employee was acting within the scope of their employment.
Let's create a scenario. I own a regional trucking company. I have strict rules in my employee handbook that drivers must never exceed the speed limit and must take mandatory rest breaks. One of my drivers, trying to finish a route early so he can go home, ignores the handbook, speeds excessively, and causes an accident while violating federal transportation regulations.
As the owner of the company, you did not commit the physical act of speeding. You were sitting in your office. You did not possess the guilty mind. In fact, you explicitly forbade the behavior. But under vicarious liability statutes, your company, and potentially you as the owner, can face criminal fines for the driver's regulatory violation.
Because I reap the financial benefits of the business, I bear the ultimate regulatory burden of my agent's actions.
Precisely. The law assumes you have the power to hire, fire, and implement training protocols. By attaching vicarious liability to the employer, the state ensures that companies prioritize compliance over speed. However, just like strict liability, modern courts usually restrict vicarious liability to regulatory offenses involving fines. Sending a CEO to federal prison for a crime committed by a low-level employee without the CEO's knowledge would trigger massive constitutional due process violations.
We have fully constructed our criminal map. We explore the physical act, the various levels of the guilty mind, and the harsh realities of strict and vicarious liability. Now, we need to pivot. We need to talk about how a defendant gets out of trouble. Let's examine the defenses, specifically the defense of making an honest mistake. If a person simply misunderstands the situation around them, does that erase their criminal liability?
The answer is entirely dependent on what kind of mistake was made and what kind of crime is being charged. The law rigidly separates mistakes into two categories: mistake of fact and mistake of law. We will start with mistake of fact, which occurs when a defendant misunderstands the physical reality of the circumstances.
The outline provides an excellent hypothetical involving a gym and a watch. Let's explore that to demonstrate how mistake of fact operates.
Imagine you are an amateur athlete. You wear a cheap, mass-produced, black plastic sports watch that costs $10. You finish your workout, walk into the locker room, and see a black watch sitting on the bench. Believing it is your cheap watch, you put it in your gym bag and walk out.
Sounds innocent enough.
Later that evening, you look closely at the watch and realize you made a terrible error. You picked up another gym member's Custer black gold luxury watch worth $50,000. The police arrive at your house and arrest you for larceny.
Larceny is the physical taking of property with the intent to permanently deprive the owner. To analyze my defense, I have to go back to our mental state buckets. Larceny is a theft offense. It is the T in our FI8 mnemonic.
Excellent recall. Because larceny is on the FI-A3 list, it is a specific intent crime. The prosecution must prove you possess the subjective internal master plan to steal another person's property.
My defense is simple. I made a mistake of fact. I honestly believe I was taking my own $10 plastic watch.
The prosecutor will aggressively attack your defense. They will hold up your cheap plastic watch next to the heavy, diamond-encrusted gold watch and tell the jury, this is the most unreasonable, idiotic mistake ever claimed in a courtroom. No rational human being could pick up a heavy gold watch and think it was hollow plastic. The mistake is completely unreasonable.
The prosecutor has a very valid point. I was incredibly careless. My mistake was foolish? So, does my defense fail? Do I go to prison for larceny?
You do not. You walk free.
Even though the prosecutor proved my mistake was totally unreasonable.
Yes, this is a massive, heavily tested rule for the MBE. Because larceny is a specific intent crime, the only question that matters is what was actually inside your subjective mind at that moment. Did you subjectively want to steal someone else's property? No, you honestly believed it was yours. Therefore, you lacked the specific intent required by the statute. For specific intent crimes, any honest mistake of fact, no matter how stupid, reckless, or unreasonable it appears to the outside world, is a completely valid defense. It entirely negates the mens rea.
That is a staggering rule. The law protects foolishness as long as it is honest foolishness. But only for specific intent crimes? How does the rule change if the crime is a general intent offense?
For general intent crimes, the law is far less forgiving. Because general intent only requires you to intend the physical action, an honest mistake is not enough to save you. To successfully use a mistake of fact defense against a general intent crime, your mistake must be objectively reasonable.
Let's apply that to a hypothetical. I am leaving a dark restaurant. I see a person in the parking lot who is the exact height and build of my best friend, wearing the exact same jacket my friend owns. My friend and I constantly play practical jokes on each other, often involving tackling or shoving. Believing it is my friend, I run up and shove the person hard into the side of a car. The person turns around, and it is a complete stranger.
You are arrested for battery, which is the unlawful application of force. Battery is not on the FIAT list. It is a general intent crime.
I raised the mistake of fact defense. I honestly thought it was my friend who consents to roughhousing.
The jury will now ask a different question than they did in the watch scenario. They will not just ask if you were honest. They will ask, would a normal, reasonable, average citizen have made the same mistake in that dark parking lot? If the jury decides your mistake was reasonable based on the lighting and the identical jackets, you have a valid defense. But if the jury decides you acted too hastily and a reasonable person would have checked the person's face first, your unreasonable mistake offers zero protection. You are guilty of battery.
That provides a beautifully clean framework for the exam. Specific intent equals any honest mistake, even unreasonable. General intent equals only reasonable mistakes. And to complete the picture, what about our floating bubble of strict liability? What if I make a mistake regarding a strict liability crime?
For strict liability offenses, mistake of fact is entirely legally irrelevant. It does not exist as a defense. Recall the bartender serving the minor. If the bartender makes a highly reasonable mistake based on an incredibly sophisticated fake ID, it changes nothing. Strict liability demands perfection. Mistakes, reasonable or otherwise, offer no shield.
We have covered mistake of fact, misunderstanding the physical world. Let's shift to the second category. Mistake of law. What if I just didn't know the law existed? Suppose I moved from a foreign country or even just across state lines, and I engage in a business practice that was perfectly legal in my old home but is a felony in my new state. I genuinely did not know the law existed, or my lawyer gave me bad advice.
You are going to encounter one of the oldest and most unyielding maxims in the legal system. Ignorance of the law is no excuse. As a general rule, a mistake of law is never a valid defense. Society operates on the presumption that citizens are aware of the criminal code of the jurisdiction they are standing in. Bad legal advice is not a defense.
What if I attempt to do my due diligence? What if I hire a highly respected, incredibly expensive private attorney? I ask them, is this complex tax maneuver legal? The attorney researches it, writes me a 20-page formal legal memo stating that it is 100% legal, and I follow their advice. 2 years later, the IRS determines the attorney was completely wrong and the maneuver is a criminal tax evasion scheme. Can I use my attorney's formal advice as a defense to prove I didn't intend to break the law?
No, you cannot. Relying on erroneous advice from a private attorney does not shield you from criminal liability. The state's criminal code supersedes your lawyer's interpretation. You broke the law. You will likely face conviction, though you might have a very strong civil malpractice lawsuit against your attorney later to recover damages. But the criminal court will not accept the lawyer's memo as an excuse.
So, mistake of law is essentially a dead end for a defense attorney.
It is a dead end in 95% of cases, but the MBE exists to test the 5% where exceptions apply. There are 3 narrow, heavily tested exceptions where a mistake of law can save a defendant. The first exception occurs when a defendant relies on an official, published government interpretation.
So if the government itself tricks me, I have a defense.
Exactly. Unless a court published a bad interpretation or the Attorney General publishes an official guidance document approving a behavior and you rely on that public document, if the court later reverses its own decision and declares the action illegal, you cannot be prosecuted for the actions you took while relying on the government's previous official statement.
That protects the basic fairness of the system. The government cannot change the rules and punish you retroactively. What is the second exception?
The second exception involves laws that criminalize completely normal, inherently innocent behavior without providing proper public notice. The law wasn't published. For example, if a small town passes an obscure ordinance making it misdemeanor to paint your front door red without a special permit, but they fail to publish the law in the town register or make it reasonably accessible to the public. If you paint your door red, you might successfully argue that the law lacked fundamental public notice. This is rare, but it exists to prevent secret laws.
And the third exception, I know from the outline this one ties directly back to our FIAT mnemonic.
Crucially, the third exception is when the mistake cancels out a specific intent.
Explain the mechanics of how a legal mistake cancels out criminal intent.
Let's examine a scenario involving debt collection. Person B owes Person A $2,000. The debt is undisputed, but Person B simply refuses to pay. Person A is frustrated. Person A tracks Person B down the public parking lot, grabs B forcefully by the jacket, reaches into B's wallet, extracts exactly $2,000, and walks away.
The physical act is a forceful taking of property from another person's body. That is the definition of robbery.
It is, but let's add a critical fact. Person A recently moved from a jurisdiction where the law explicitly allowed self-help debt collection. Person A genuinely, honestly believed that the civil law of his current state gave him the legal right to forcibly reclaim his own property. He was completely mistaken about the law.
We just established that ignorance of the law is no excuse.
But we must analyze the specific intent requirement. Robbery is a theft offense, the T in FIAT. It requires the specific intent to unlawfully deprive someone else of their property. If Person A honestly believed the law recognized the $2,000 as his own rightful property, he did not possess the specific intent to steal someone else's property. He intended to reclaim his own.
Wow. The mistake regarding the civil law of debt collection destroyed the mens rea required for the criminal charge of robbery. You lose this specific intent to rob.
Precisely. His legal misunderstanding negated the specific intent. Now, to be clear, Person A is not walking away innocent. He still forcefully grabs Person B. He is guilty of assault and battery, which are general intent crimes regarding the physical force, but he will escape the much more severe felony charge of robbery because his mistake of law erased the specific intent to steal.
That is a brilliant example of how interconnected these concepts are. You cannot analyze a defense without first mapping the crime onto the FI list. We have now built the entire framework of criminal liability and the defenses against it. But there is one final foundational question we must address before we close this deep dive. Before a prosecutor can argue about your mind map, they have to prove they have the power to put you on trial in the first place.
You are referring to jurisdiction. Who runs the trial? This is the structural foundation of the legal system. It answers the question, does this specific sovereign government possess the constitutional authority to put this specific defendant on trial for this specific act?
State versus federal power. In the United States, we operate under a system of dual sovereignty. We have 50 individual state governments, and we have one federal government. They operate simultaneously, but their powers to create criminal laws are vastly different. Let's start with the states. Where do states derive their authority to declare actions illegal?
Using simple English, states have broad police power under the 10th Amendment. They make most of the rules. The police power grants state legislatures the right to enact any law necessary to protect the health, safety, welfare, and morals of their citizens.
Health, safety, welfare, and morals. That covers virtually human activity.
It does. It is a massive umbrella. Murder, assault, burglary, speeding, zoning violations. The vast majority of everyday criminal law is created by the states utilizing their police power. They are the primary regulators of human behavior.
What about the federal government in Washington, D.C.? Do they possess a federal police power to regulate the morals and safety of the entire nation?
They do not. The federal government has very strict, limited power. Only things mentioned in the Constitution, like treason, counterfeiting money, or crimes in national parks. Congress cannot simply look at a societal problem and pass a criminal law to fix it unless they can point to a specific clause in the United States Constitution granting them the authority to act.
If Congress wants to make something illegal, they have to find a constitutional hook to hang it on. What are the primary hooks they use?
The Constitution explicitly grants Congress the power to criminalize treason, piracy on the high seas, and the counterfeiting of national currency. They also possess exclusive jurisdiction over federal property, which allows them to pass criminal laws governing conduct inside national parks, on military bases, and within the District of Columbia.
But the FBI investigates much more than just counterfeiting and crimes in national parks. They investigate massive drug cartels, internet fraud, and organized crime. Where does that power come from?
The vast majority of modern federal criminal law is built upon the Commerce Clause. The Constitution grants Congress the power to regulate commerce between the states. Over the last century, the courts have interpreted this broadly. If a criminal enterprise crosses state lines like drug trafficking, wire fraud using the internet, or transporting kidnapped victims across borders, it affects interstate commerce, granting the federal government the jurisdiction to prosecute it.
That explains the division of power between the sovereigns. But even when a state or the federal government has jurisdiction, the Constitution places absolute limits on how they can wield that power to protect individual citizens.
If we connect this to the bigger picture, there are constitutional rules both governments must follow. They cannot punish you for something done before it was illegal, which is called ex post facto. They can't punish without a trial, which is a bill of attainder. And laws cannot be too vague, which falls under due process.
Ex post facto. Let's translate the Latin. It means after the fact.
The ex post facto clause prohibits the government from retroactively altering the criminal law to disadvantage a defendant. The most obvious violation is making an action a crime today and then arresting someone for doing that action yesterday, back when it was perfectly legal.
The government cannot change the rules of the game after the play is over.
Exactly. But it goes further than just creating new crimes. The government also cannot retroactively increase the punishment for an existing crime. If the penalty for burglary was 5 years in prison when the defendant committed the act, the legislature cannot pass a new law raising the penalty to 10 years and apply it to that specific defendant. They also cannot retroactively alter the rules of evidence to make it easier to secure a conviction for a past crime.
The law is frozen at the moment the physical act was committed. What is a bill of attainder? That term sounds incredibly archaic.
It is archaic because the Constitution banned it, but it was a common tool of the British Parliament. A bill of attainder is a law passed by the legislature that essentially acts as a judicial verdict. It is a legislative act that declares a specific individual or a specific easily identifiable group of people guilty of a crime and imposes punishment without the benefit of a trial.
So, Congress cannot pass a law that says, John Doe is hereby declared guilty of treason and his property is seized.
Precisely. The Constitution demands the separation of powers. The legislature's job is to write laws that apply to the general public. It is the sole job of the judicial branch, the courts, and the juries to determine if a specific individual violated those laws. Bills of attainder bypass the courts entirely, which is why they are strictly forbidden.
The legislature writes the rules, the courts run the trial. That brings up one final constitutional protection mentioned in the outline, the vagueness doctrine, derived from the Due Process Clause.
The Due Process Clause demands fundamental fairness in the legal system. A key component of fairness is that citizens must receive fair warning about what behavior is prohibited. A criminal statute is considered void for vagueness if it is written so poorly, or uses such incredibly broad language that a person of ordinary intelligence has to guess at its meaning.
Give me an example of a law that is void for vagueness.
Historically, many cities passed vagrancy ordinances. A law might state, it is a misdemeanor for any person to be a loafer, a vagabond, or to wander the streets without apparent purpose. The Supreme Court struck these laws down.
Because wandering without purpose is too subjective. A person looking at the architecture of the city is wandering without specific economic purpose.
Exactly. When a law is that vague, it doesn't actually provide a rule for citizens to follow. Instead, it just hands arbitrary power to the police, allowing them to arrest anyone they find undesirable under the guise of loitering. Due process requires statutes to draw clear lines so citizens know how to obey the law.
What if I stand in State A and shoot a gun across the border, and the bullet hits someone in State B?
If any piece of the crime, the act, or the result happens in a state, that state can hold the trial. The rule for state territorial jurisdiction is expansive. If any material element of the crime occurs within a state's borders, that state can claim jurisdiction. State A has jurisdiction because the actus reus, the physical act, happened there. State B has concurrent jurisdiction because the causation of harm happened there. Either state has the authority to prosecute you.
What if we expand the hypothetical to include a conspiracy? What if I am sitting in my living room in State A? I use my cell phone to call a professional hacker located in State B. We agree to a plan to electronically rob a bank that is headquartered in State C.
The web of jurisdiction expands accordingly. State A has jurisdiction because the agreement was partially formed there. State B has jurisdiction because the other half of the agreement occurred there. And State C has jurisdiction because the intended result of the conspiracy was directed at their territory. In the modern era of interstate travel and digital communication, jurisdictional overlaps are incredibly common.
You cannot play border games to escape the reach of the law. We have covered an immense amount of complex legal terrain today, moving from the physical world to the invisible mind, navigating the strict rules of liability, exploring the nuances of legal defenses, and defining the constitutional limits of government power. And we did it without relying on the dense, archaic language that makes textbooks so impenetrable. Let's quickly review the visual tools built today for the ESL learner. First, we constructed the triangle mind map. Point 1, the bad act, or actus reus. Point 2, the guilty mind, or mens rea. Point 3, causation.
Then we mapped the anomaly, the floating bubble outside the triangle, strict liability.
We also mapped out the supercop's duties to act, statute, contract, relationship, undertaking, and causation. And we attached our vital mnemonic to the specific intent bucket, FIAT, first-degree murder, inchoate crimes, assault with intent, and theft.
Those are the crimes requiring a master plan.
To our listener preparing for the bar exam, especially those tackling this material in a second language, I want to offer this reassurance. The Latin words might seem scary, but broken down into simple English, it's just a logical system of human behavior. You have the structural tools now, you have the mind map, you can absolutely conquer this material.
Before we conclude, I want to leave you with a thought experiment not fully answered by the text, pushing you to think beyond the MBE. We talk heavily about the voluntary physical act, but as we move into an era of brain-computer interfaces, like neural implants, what happens if a computer chip in your brain malfunctions and causes your arm to strike someone? Your brain had the bad thought, the machine caused the physical reflex. Where does the law draw the line between human intent and machine omission? Something to think about as you study.
That scenario shatters our triangle completely. It is a fascinating puzzle that your generation of lawyers will have to solve in real courtrooms. Thank you for joining us on this deep dive, and best of luck on the bar exam.